Hi, my name is Rajni Kevadia. I am from group M417 and there are other three members of my group, Kamalpreet Kaur, Akanksha Gupta and Wale Mahmood and myself Rajni Kevadia. I am going to describe about case 1. The issues to be considered in the case are whether there was an unconscionable bargain or not. The present case is concerned with the mental capacity of a person to enter into the contract. So one party was mentally not prepared. It means the one party was mentally ill. Rules. Court considered the contract to be answer in equity because of the one party was insane. There are two types of unfair contract. One was procedural and another one was contractual unfairness. So contractual unfairness takes place when there is no balance between the rights and liability of the other party. So there is no chance of other unfairness, because contractual unfairness takes place because of one person was not mentally prepared and he was mentally ill. The next application is going to be present by one of my friend.
About the mental capacity of parties, which is not like in this contract. One party was mentally ill, which was Mr. Jack, and he was suffering from mental dilemma, and according to the law he cannot be entering any contract with the other party. So with the Mr. Hart, it was void contract, which was another, as it was explained before my friend. And in this case, Arthur versus further explained that the parties have capacity. Again, in this case, by law, you cannot enter with the party who don't have mental capacity. In this conclusion, it was therefore held in this case that the contract should be set aside on the ground of unfairness, and that there was an unfair treatment because the parties were not an equal and similar footing. Like Mr. Hart was the neighbor of Mr. Jack O'Connor, and Mr. Jack had a two nephews. Later on, when they get in the contract, after that contract, both Mr. Jack was right, and his nephews, both of them, they hired another legal solicitor for them, and they took a legal action against Mr. Hart. So the case in the court, the case was voidable and it was null and void, and there was no case because Mr. Jack was
Hi, my name is Akanksha. I am a member of group M417. I'll be explaining the corporation law, and the case is Campbell case of 1924. So a brief history about the case. The case is about Mr. Campbell, who went as an editor in the National London's Weekly and gave a written statement in the paper that any of the soldiers were not supposed to fire in any of the civil wars or any political ones, which ultimately led to the fall of the communist government in London. So the cases were as follows. The main issue was that the statements given by Mr. Campbell was orally. So was it admissible in the court or not? Also, his oral statements were quite related to the written ones or not. So the next one is, so according to the hearing in the court, the conclusion was made that there was a breach of contract, as the statement was given both orally and written. As a result, the written statement was not admitted by Mr. Campbell in the hearing of the court, which led to the breach of contract and led to the falling of communist government in London. Also, the written contract is to be valid no matter what, as it binds the contract. That means oral statements were not admissible in the court of law until and unless it can be proved by the hearing party or the party who is making any kind of decisions. Also, the parallel evidence is a way of understanding the English common law. No evidence can be made prior to the already existing written document. So there were certain applications and certain rules that were applied in the law of court in London. These will be explained by Ms. Kamalpreet Kaur. Thank you so much.
Hi, I'm Kamalpreet Kaur. Now I will continue the case number 2 by explaining application and conclusion. So the case is that the journal looks at the application of a written contract and how far it can be waived or held. Court tries to understand if there has been a breach of the agreement. The parties had mutually agreed to be bound by the agreement. That there was a clear case of an oral negotiation that have